All right, here's appeal docket number 28 on Schaeffer's appeal case 13-30,000. It's 91 pages, so I'll probably read like 20 pages at a time and take a break like I normally do. The first document is letter/motion for leave to file supplemental exhibit to motion for new counsel and to urge both motions be granted. January 7th, 2014. Dear Court Administrator, Appellant respectfully requests leave of the court to file the attached bar complaint and letter to Miss Elliott, counsel, and to urge both motions for stay and remand pending before the court be granted. Filed at docket on December 2013. Sincerely, Schaeffer Cox. Certificate of Service and Verification of Facts comes now. F. Schaeffer Cox, being natural citizen of the United States over the age of majority, and subject to penalty or of perjury under 28 U.S.C. 1746, and as incarcerated indigent prisoner proceeding in propria persona pursuant to FRAP 4C Houston v. Lack 108 SCT 2379 1998, and so certify that the facts presented in my attached letter/motion for leave to file supplemental exhibit along with the supplemental exhibit itself are true and correct to the best of my knowledge and beliefs. Further, I so certify I have sent an original and 3 true copies thereof to the Clerk of Court for the U.S. Court of Appeals of the Ninth Circuit, and a true copy to the Honorable U.S. Attorney Karen L. Loeffler and to appointed appellate counsel Suzanne Elliott, all correctly addressed with proper U.S. first-class postage, duly affixed thereto for posting in the U.S. first-class mailing by personally delivering same to Henry Rivas or Mr. Burgess for proper legal mail posting as per federal BOP policy. That same is filed once delivered to proper FBOP officials on this 8th day of January 2014. So swear I under penalty of perjury. Francis Schaeffer Cox, he even put his thumbprint. Okay, supplemental exhibit to motion for new counsel and to urge both motions be granted, part 1. Related grievance against Miss Suzanne Lee Elliott, WSBA 12634. Dear Disciplinary Counsel, please find enclosed a copy of the letter I sent to Miss Elliott regarding her ethics violations and violations of the rules of professional conduct. I ask that you treat this letter as a preliminary complaint, and send me the Washington Bar Association's rules of professional conduct as well as the proper forms to further establish my complaint. Upon receipt of proper forms and reference material, I will file a superseding grievance that more pointedly addresses Miss Elliott's professional misconduct. Respectfully, Francis August Schaeffer Cox. Supplemental Exhibit Part 2. This is a letter, it looks like, from Francis to Miss Suzanne Lee Elliott, Esquire, Attorney at Law, 1300 Hogue Building, 705 2nd Avenue, Seattle, Washington, 98104. Dear Miss Elliott, I am in receipt of your motion to stay and remand for competency hearing, and I am in receipt of your response to docket 23, government's motion for clarification. I have not received a copy of the government's motion for clarification. Therefore, I do not know if the government's motion for clarification was in regard to your motion for stay and remand for competency hearing or in regard to my motion for stay, motion to order government to disclose all Brady Giglio Kyle's material and hearing thereon, and my motion to appoint new counsel. You will please note attached here too is a copy of my letter to the Ninth Circuit Court of Appeals, court administrator, complaining of your failure to provide service to me and requesting that the court require both you and the government perform service to me based on now adversarial positions, Exhibit A. I was astounded to read at lines 11 through 13 that I was quoted in a news article as stating I feigned mental illness in my pre-sentence mental evaluation. Why would you not first ask me if I made such a statement? I did not say that. It is a mischaracterization taken out of context. I said, as I have previously, I was in an altered state of mind due to my panicked fearful response to the federal prosecutorial team, to wit, Joseph W. Bottini, AUSA, Nicholas A. Marsh, deceased, AUSA, Stephen Scrocky, AUSA, James A. Grokey, AUSA, Yvonne Lamoureux, AUSA 2nd, then law enforcement investigative team, among others, to wit, FBI Special Agent Sandy Klein, FBI Special Agent Richard Sutherland, and then confidential informants Aaron Bennett, Bill Fulton, and J.R. Olson, who ran their multi-million-dollar, 3-year-long sting in an effort to provoke me into committing violent, unlawful acts out of fear of being harmed by the undercover CIs posing as militia members. It was FBI agent or agents improperly supervised by the prosecution investigation team, who orchestrated, promoted, and utilized the threats made by the CIs or federal agents to make me fearful for myself and my family and friends. See Exhibit B. You are well aware, it is documented, Aaron Bennett urged me to commit violent acts and I distanced myself from him. You are well aware that it is documented that CI Benedict Arnold Bill Fulton made violent threats to kill me and my friend Les Zerby because we had no plan to commit violent acts while brandishing a knife and holding it to Les Zerby's throat. You are well aware that a credible member of the armed forces and the military police at Fort Wainwright, Steve Gibson, who never met me, after being approached by a U.S. Marshal and an FBI agent, was so concerned by their conversations about hoping I would resist arrest and could be killed that he looked me up and personally warned me my life may be in danger. You are well aware that the Joint Defense Team's audio tape expert told the defense that he believed the recordings had been altered and edited to prove he needed access to the original tapes before they were reformatted. You are aware Prosecutor Stephen Scrocky misled the court, misstating the copy the defense had was the same as the original, and this was a defense effort to delay trial. The trial court then denied our request, preventing our expert from being able to testify on our behalf. You should be aware that the Phantom Hit Squad was foisted on me by the CIs in this case. Yet you have presented these issues as if they are delusions from what must be my mental illness. Also, you have cherry-picked Miss Robin Ledoux's evaluation, ignoring that she defined diagnostic criteria for 301.0 paranoid personality disorder. 1. Suspects without sufficient basis that others are exploiting, harming, deceiving him or her. Is preoccupied with unjustified doubts. Is reluctant to confide in others because of unwarranted fear. You have ignored where the evaluator stated, as well as an intense reaction to a perceived situational threats. This appears to have been the situation with Mr. Cox and the federal government and the government's informants. Miss Suzanne Elliott, Esquire, January 2nd, 2014, page 3. In this case, it is difficult to ascertain whether he, Mr. Cox, had schizophrenia and/or paranoid and/or delusional disorders due to an ongoing involvement of others that supported his delusions. He, Mr. Cox, needs to be protected from people who instigated and supported his delusions. You have totally ignored Peter Camille's sentencing memorandum, including the following at page 9. Finally, the influence of the government informants played a key role. The more the government informant instigated Mr. Cox, the more paranoid he became. You have totally ignored Peter Camille's sentencing reports from page 9, overview of the charged counts, page 9 through 10, the KJNP security detail on page 10 and 11, the 241 plan, page 11 through 18, Schaeffer Cox's fear of the government, page 19 through 20, Schaeffer Cox's fear of Bill Fulton, page 20 through 24, the conditional nature of the conspiracy and solicitation to murder federal officials, pages 24 through 26, sentencing entrapment, pages 38 through 41. See attached Exhibit B. Peter Camille's sentencing memorandum clearly states that there is a basis for my fear paranoia that was induced by the prosecutorial and law enforcement team during the Polar Pen Task Force investigation. You have characterized me as a falsely attacking / hating U.S. government in your pleadings. This is untrue. I have at times opposed U.S. policies. I believe in working within our system. I have memorized our Constitution. I ran for public office. It is the U.S. judicial system, the circuit judges on the Ninth Circuit, to whom I am trusting to provide relief from an unjust conviction. I am trusting in the DOJ and their public Office of Professional Responsibility. their Division of Public Integrity, and their Office of the Inspector General. I have asked you to help me present my complaints against Joseph W. Bottini, James Grokey, Nicholas Marsh, Stephen Scrocky, Yvonne Lamoureux, and their Polar Pen enforcement agents regarding their violations of rules, policies, ethics, and laws in mine and other cases. When I asked you for help, you replied in your letter to me on July 23, 2013, "I do not believe an appeal to anyone in Washington, D.C. will assist you," page 2, Exhibit C. You further stated that a direct appeal is based solely on the evidence admitted at trial or testified by the witnesses. If it was not admitted at trial, it is as if it never happened. You cannot take evidence outside the record and now insert it into the proceedings. See Exhibit C. In July 1st, I accepted your words at face value, albeit I was raising this in the context of evidence outside the record because the trial court ruled it inadmissible and would not admit my statements made while I was unknowingly recorded by CIs or when I gave an 8-hour uncounseled statement to the FBI. This based on the Polar Pen prosecution team's motion to keep my state of mind mens rea statements corroborating my trial testimony out of court, as well as the original non-edited versions, tapes of the government's recordings. So then I have found numerous cases in the Ninth Circuit and elsewhere where precisely such non-admitted evidence, non-admitted at trial, is the subject of successful appeals. I feel you misled me on this matter. See Exhibit D, State of Mind cases and review thereof. I wrote you that the prosecutors knew their CIs were being untruthful and that the prosecutors knew I testified truthfully at trial, and that the same thing I said when being recorded without my knowledge when I gave an 8-hour uncounseled statement to the FBI, which the prosecutors were able to suppress. Further, I told you that the prosecutors did not correct the perjury of their witness and instead bolstered and vouched for them in closing argument, while falsely telling the jury my testimony was a fabrication, and I believe this was outrageous prosecutorial misconduct. In your letter of September 16, 2013, you replied stating in part, "If there are Brady violations apparent from the record as presently developed, then we can certainly raise arguments about the government's failure to provide you with all the exculpatory evidence in this case. But I caution you that while you believe some of the witnesses' testimony was perjurious, the government's point of view is that these witnesses were telling the truth." Exhibit C. Why were you so quick to tell me that the government, ergo Polar Pen prosecution, believed that their witnesses were telling the truth, instead of knowingly allowing perjurious testimony to go to the jury uncorrected that the prosecutors vouched for and bolstered during their closing argument? Why would you not think it was possible that the prosecutor violated court ethics by knowingly making false statements to the tribunal and the jury and telling the jury during closing arguments? Schaeffer Cox tells Lonnie Vernon, "But Bill Fulton, I'm afraid it's going to kill me. Aaron Bennett, I'm afraid, is trying to kill me. I submit to you folks, you try to find a statement anywhere about Bill Fulton's trying to kill me, Aaron Bennett's trying to kill me. You can look through 900 pages of it. You're not going to find it. But the deal is, you're not going to find any evidence except that this guy Cox said on the stand last week that Bill Fulton and Aaron Bennett were out to kill him. Frankly, folks, Cox lied to you, and he's lying to you. We call baloney on that. I don't have the Alaskan or Washington Bar Association rules or Washington or Alaskan District Court rules of professional conduct, but I have the Washington, D.C.'s rules of professional conduct, and Rule 3.32 is prohibits an attorney from making a false statement of material fact or law to a tribunal. Further, given that the Washington, D.C. District Judge, the Honorable Judge Emmett G. Sullivan, stated found at 715 F Supplemental 2D1 USDC Washington, D.C. 2009 the following. On December 11, 2008, the government filed under seal a copy of a complaint made by an FBI agent assigned to the investigation and trial of the defendant, Senator Ted Stevens. In the complaint, the agent states that as the co-case agent of the Stevens investigation, he witnessed or learned of serious violations of policy, rules, and procedures, as well as possible criminal violations. The complaint alleges, among other things, that prosecutors on the case schemed to relocate a government witness who had been subpoenaed by both government and the defendant. In order to avoid having the witness testify at the trial, attempted to conceal exculpatory information from the defendant and mishandled evidence. The complaint also alleges that the lead FBI agent in charge of the investigation fostered an inappropriate relationship with the government's main witness, intentionally redacted exculpatory information from a document turned over to the defendant in order to make the document fit with information previously provided to the defendant, and violated numerous rules and regulations, including disclosing to a source that another source had testified before the grand jury. In the face of what appears to be another incident in an ongoing series of incidents in which the court has relied on information provided by the government only to later learn that the government had misled the court and or misrepresented the facts, the court sought an explanation from officials at the Department of Justice. And that in related special proceedings, 842 F.Sup. 2D 232 U.S.D.C. Washington, D.C. and the following. Meanwhile, in the face of a serious and mounting allegations of prosecutorial misconduct throughout the trial and post-trial proceedings, the attorneys repeatedly represented to the court and to the public that there was no wrongdoing and no cause to investigate and no cause to question the integrity of either the indictment or the verdict. Only when faced with controverted evidence that the attorneys had committed Brady violations did the government come before the court and publicly move to dismiss the indictment and vacate the verdict. And only at that point did the government seek to turn this public proceeding into a private one, assuring the court that it would investigate the prosecutors internally through its confidential Office of Professional Responsibility process. On November the 22nd, 2011, the court issued an order indicting internal alia that Mr. Schulke had informed the court that his investigation was concluded and had submitted a 500-page report to the court in camera. Order regarding report of Henry F. Schulke III and setting forth instructions for further proceedings at 12, November 21st, 2011 order. The court's order went on to note that based on their exhaustive investigation, Mr. Schulke and his esteemed colleague, Mr. William B. Shields, had concluded that the investigation and prosecution of Senator Stevens were permeated by the systematic concealment of significant exculpatory evidence, which would have independently corroborated his defense and his testimony, and seriously damaged the testimony and credibility of the government's key witness. ID at 3, citing Mr. Schulke's report. After a highly publicized trial and months of post-trial proceedings, during which the prosecution team repeatedly denied any wrongdoing and zealously defended the guilty verdict it had obtained, the opposing attorneys cannot now circumvent the First Amendment and any public accountability by relying on the government's 11th hour motion to dismiss the indictment with prejudice. In response to those arguments, the subject attorneys repeatedly responded that the mistakes were unintentional, inadvertent, and or immaterial. For example, when the government failed to produce the exculpatory grand jury testimony of prospective government witness Rocky Williams, the prosecutors claimed that the testimony was immaterial. See government's opposition to defendant's motion to dismiss for a new trial, Stevens, September 29, 2008, when the government sent Mr. Williams back to Alaska without first advising the defense or the court. The prosecutors asserted that they were acting in good faith. Trial transcript October 2nd, 2008, 2 p.m. at 42, when the government counsel told the court that the government's key witness, Bill Allen, had not been re-interviewed the day before his hearing on Brady disclosures. This was a mistaken understanding. Government's opposition to defendant's motion to dismiss due to alleged misconduct at 15 October 6, 2008, when the government failed to turn over exculpatory statements from Dave Anderson, another government witness. The prosecutors claimed that the statements were immaterial. Trial transcript October 8, 2008, p.m. at 58, 62, 64, and 67. When the government failed to turn over grand jury transcript containing exculpatory information, the prosecutors claimed that it was inadvertent. Trial transcript October 6, 2008, that the government knew to be false. The prosecutors said that it was unintentional. Trial transcript October 8, 2008, p.m. at 76. When the government failed to produce the bank records of Bill Allen and then surprised the defense at trial with Bill Allen's check, it claimed that this, too, was immaterial to the defense. Trial transcript October 8, 2008, a.m. at 3. Notwithstanding, Notwithstanding mounting evidence to the contrary, the court accepted the prosecutor's representations and declined to dismiss the case or declare a mistrial, though the court did take other steps to ameliorate the prejudice to the defense. Had the court known of the misconduct and information concealed by the government and documented in the Schulke report, those decisions would have been different. As the court noted in its November 21, 2011 order, Mr. Schulke and Mr. Shields found that the investigation prosecution of Senator Ted Stevens was permeated by the systematic concealment of the significant exculpatory evidence which would have independently corroborated his defense and his testimony, and seriously damaged the testimony and credibility of the government's key witness. See November 21, 2011 order at 3, quoting Mr. Schulke's report at 1. Mr. Schulke and Mr. Shields found that at least some of this concealment was willful and intentional, and related to many of the issues raised by the defense during the course of the Stevens trial. In addition, they found evidence of concealment and misconduct previously unknown to the court and to the defense, even after the government moved to dismiss the indictment. For these reasons, access to the report would certainly play a positive role in informing the public of the flaws in the criminal trial of Senator Stevens. It is also significant to this analysis that the information revealed as a result of the government's motion to dismiss and the indictment and vacate the verdict in the Stevens case, and this court's decision to appoint Mr. Schulke to investigate the subject attorneys had dramatic implications for two other individuals convicted by the Public Integrity Section as part of the Polar Pen investigation of Alaska political corruption. Peter Cott, former Speaker of the Alaska House of Representatives, and Victor H. Coring, a former member of the Alaska House of Representatives, had been convicted and were serving prison sentences on bribery and extortion-related charges, and the government moved to dismiss Stevens' case, and the court appointed Mr. Schulke. Because of these events in April 2009, Mr. Cott and Mr. Coring moved for release from custody and for disclosure of all Brady material in their own cases. In June of 2009, the government uncovered Brady material in both cases and asked the Ninth Circuit to remand the cases to the District Court of Alaska and to immediately release Cott and Coring on personal recognizance. The Ninth Circuit granted the requested relief. See Order U.S. v. Coring, 334, Fed approximately 836, Ninth Circuit 2009, Doc number 41, Order U.S. v. Cott, 333. March 2011, the Ninth Circuit found that information suppressed by the government in both cases were favorable and material to the defense, and the prosecution violated Brady and Giglio v. United States. 405 U.S. 15092 763 LED 2D 104 1972. The Court of Appeals vacated the convictions and remanded the cases to the District Court for new trials. See United States v. Coring. On October 21st, both men pleaded guilty and they were sentenced to time served. Richard Marr, corruption trial ended. Cott, Coring pled guilty, sentenced to time served. Anchorage Daily News. And in U.S. v. Peter Cott, 423, approximately 736 at page 738, U.S. Circuit Judge and Honorable Betty Fletcher in her dissent stated, I am deeply troubled by the government's lack of contrition in this case. Despite their assurances that they take this matter seriously, the government attorneys have attempted to minimize the extent and seriousness of the prosecutorial misconduct and even assert that Cott received a fair trial despite the government's failure to disclose thousands of pages that reveal in part prior inconsistent statements by the government star witnesses, Bill Allen and Rick Smith, regarding the payments of Cott allegedly received. The undisclosed pages also reveal an ongoing investigation of Allen for sexual exploitation of minors and his attempt to suborn perjurious testimony from one of the minors, and information regarding Smith's questionable mental health around the time of Cott's trial. The government's stance on appeal leads me to conclude that it still has failed to fully grasp the egregiousness of its misconduct, as well as the importance of its constitutionally imposed discovery obligations. Because a new trial, in my view, is insufficient to remedy the violation of Cott's constitutional right to a fair trial and to deter future illegal misconduct, I would exercise our supervisory authority to dismiss the indictment with prejudice. Given the above, you replied to my Brady outrageous misconduct concerns in your letter of September the 16th, 2013, previously cited, and in your letter of September the 3rd, 2013, wherein you stated, I believe that the first four likely have legs in the appeal. As to number 5, outrageous government misconduct, we would have a difficult time prevailing on that theory. Absent the revelation of some huge Brady violation or other truly outrageous conduct, that issue probably does not have legs. See Exhibit C. I had no knowledge of the cot coring or way rancher cases, but I'm certain you did. You knew that their counsel successfully moved the Ninth Circuit for a remand of the hearing on the Brady Giglio Kyles violations to expand the record. The Brady violations that happened in the other cases around the same time as mine pale in comparison to the AUSA's refusal to disclose Bennett's role as a CI or to turn over the evidence he produced over his 4 years of involvement. From the start of your appointment as appellant counsel, I have advised that I want to raise issues surrounding Frank's hearing and trial court's decision to not suppress the evidence in the trailer and allow its admission along with the inculpatory portion of the improperly edited, altered tapes. I believe this was clear error and the abuse of judge's discretion, that the district court erred and it ruled to suppress exculpatory recordings made by the FBI that clearly showed my state of mind, lack of intent, and unwillingness to plot a crime. This suppression barred our whole defense and deprived me of due process, that there were our estoppel arguments to my firearm charges. There was evidence to establish that I had gone to the local ATF office and inquired as to whether or not I needed a tax stamp or a homemade WW2 replica gun. A tax stamp on a homemade WW2 replica gun, and that I was acting in good faith upon what I was told. I believe it is clear error for the trial judge to deny our pre-trial motions on it, citing that it was a question for the jury, and then at trial to bar any argument regarding that the defense to the jury he ostensibly had deferred to earlier, and that there are colorable arguments to be made on the conspiracy charges as to the conditional nature of the conspiracy, with no real viable object. These arguments put forth by Peter Camille in his sentencing memorandum, and those put forth by Robert John Esquire in his letter to and conversations with you. The prosecutorial/law enforcement misconduct issues of improperly supervising their confidential informants, allowing them to use threats of force, bodily harm, or death, and actual physical violence with a knife to try to coerce me into committing a crime or crimes. Continuing the undercover sting for 3 years when I repeatedly refused to engage in or agree to acts of violence. Failure to disclose Brady Giglio Kyle's material, including improper relationships between the FBI agents and their CIs, editing, altering the audio tapes, making clearly false statements in the arrest/search warrants and to the grand jury, concealing the Aaron Bennett was an ATF informant, and the prosecutor CI, allowing Bennett to become an enemy agent inserted in the defense camp by meeting repeatedly with my investigator Rolleport, meeting with defense counsel repeatedly, and testifying as a defense witness while being a government informant operative who has probably recorded me for the government, and those tapes were suppressed. That the government suppressed 302's debriefing of Aaron Bennett's and to those conversations, meeting with me with my investigator and attorney, if not attorneys. The AUSAs engaged in the obstruction of justice when the defense investigator Rolleport asked for audios made by CI Bill Fulton rather than turn over the requested audios, that AUSAs turned them over to CI Bill Fulton, who subsequently destroyed them, or so we are told. For the year you've been my appellant counsel, you've never told me the issues you wanted to raise or how. You've never gave me any case law as to how the Ninth Circuit has ruled on similar facts and law as to the issues I wanted raised. I have access to an electronic LexisNexis law library. I know how to shepherdize and do basic research. The only issue you've really said you wanted to raise was my mental competency, which I've repeatedly told you that I didn't want to raise, and why. See Exhibit C. You have never been precise in the issues you should raise or give me any case law supporting those issues, and conversely, you have never given me any specifics that were accurate as to why the issues I wanted to appeal on were losers. You never gave me any cases I could look up and see you're right and that appeal issue won't fly. There is a Ninth Circuit precedent against it. I've never asked you to send me to law school, but you have abjectly failed to keep me even reasonably informed when I could make an informed decision. We've talked 30 minutes in a year. 2 deadlines for the original brief passed, and I never saw your draft brief until I visited Robert John, Esquire, on December 30th, 2013. It was approximately 700 sentences out of 1,300 allowed, or approximately 7,500 words out of 14,000 allowed. You never asked me, but abandoned any appeals of the firearms convictions, where on some I'm serving 10 years. The issue you abandoned included the Franks hearing and the suppression of estoppel issues, which all my other lawyers felt were winnable. You didn't raise or brief the conspiracy issues raised by Robert John or Peter Camille. Instead, you raised only a jury instruction issue, to which there was no objection at trial and as such was not preserved. But you raised it as a plain error, a very difficult standard to overcome, while abandoning attacks on the conspiracy to kill officials or solicit someone to do so, where there were objections and preserved appeal issues. Lastly, albeit I've repeatedly told you I did not want to raise the mental illness issue on appeal, you spent a lot of time and space on your statement of facts addressing/supporting that premise, and then raised it on direct appeal as ineffective assistance of Nelson Traverso, without discussing this with me at all. You never discussed what ramifications this might hold for me in a later 2255 proceeding on this issue and or other claims of IAC against, I think IAC means ineffective counsel, against Mr. Traverso. In the Ninth Circuit, if the Ninth Circuit decides the record is not complete enough as to the factual predicates of this claim, would it procedurally bar me from re-raising it in district court? Would it risk barring me from raising other separate IAC against counsel Traverso, which I believe exist? Rowleyport and Tim Dooley, Esquire, both said they would give me affidavits as to his ineffectiveness. While there are risks to your unilateral decision to raise this issue now, as well as risk to being procedurally barred later in a 2255 or IAC against Mr. Traverso, there is no such risk of being procedurally barred later by not raising it. The IAC claim in related to mental competence on direct appeal. See Massaro versus United States 155L.ed.2D 714-2003, which held a defendant can't be later procedurally barred on 2255 for failing to raise ineffective assistance of counsel on direct appeal. Justice Kennedy, writing for unanimous court, applying that rule to ineffective assistance claims would create a risk that defendants would feel compelled to raise the issue before there has been an opportunity to fully develop the claim's factual predicate, and would raise the issue for the first time in a forum not best suited to address those facts, even if the record contains some indication of deficiencies in a counsel's performance. A 2255 motion is preferable to direct appeal for deciding an ineffectiveness assistance claim. When a claim is brought on direct appeal, appellant counsel and the court must proceed on a trial record that is not developed precisely for and is therefore often incomplete or inadequate for the purpose of litigating or preserving the claim. You yourself must feel the record lacks a successful factual predicate to sustain this issue on direct appeal for you. Would not have filed the motion for stay and remand for competency hearings under 18 U.S.C. 4247. I know I don't need to, nor could I, send you to law school, but raising this now as IAC makes no sense to me. When you declined to help me on the polar pen misconduct, I filed the pro se motion to stay, motion for an order to require the prosecution to disclose all previously withheld, suppressed Brady Giglio Kyle's materials. A motion for remand as in caught and coring and appointment of new counsel. You appear to have been highly offended and thus responded with your motion for stay and competency hearing. You seem to feel I must be mentally incompetent to dare to challenge your appellate decisions. You opined that since I tried to fire Mr. Traverso during trial, I would just try and fire any newly appointed attorney as well. Yet you were well aware that after paying Mr. Traverso over $150,000, Mr. Traverso told me he would not attempt to introduce my state of mind evidence or recordings of me refusing to plot a crime. You will recall I objected personally to the trial court. This is why Mr. Port and Mr. Dooley and Tim Dooley, Esquire, offered to give me the affidavits in support of Traverso's IAC. That was the core of my defense, my state of mind, and would have corroborated my trial testimony. Perhaps the FBI has the right to try to talk me into plotting a crime, but I have the right to refuse, and I have the right to not be attacked with a knife for refusing. I have the right to not receive ongoing death threat ultimatums from confidential informants. I have the right to leave the country with my family to get away from ongoing death threat ultimatums. I have the right to present evidence of my state of mind and my effort to leave the country to a jury. So far, none of those rights have been respected. What could arguably be my last right left is the right to have the appellate court review those violations of my rights. And that is a right that you are not authorized to waive from me, against my will and above my objections. I will be perfectly satisfied with the appellate counsel who will raise the 5 issues I addressed in this letter. You never talked to me about filing the motion to stay and remand for competency hearing. You never spoke to my wife, mother, father, sister, or brother before you filed it the same day you got my motion for stay and remand. You never spoke to Mr. John Peter Camille about this either. You haven't read the discovery, reviewed the non-admitted evidence, or given any consideration to Mr. Camille's sentencing memorandum. You have also refused to listen to Mr. John or make any effort to obtain Mr. Port's reports. Had you done any of these things, you would have known that there was a factual basis for my panicked reaction to the investigation's violent coercion. You have ignored all that and instead told the Ninth Circuit my testimony was delusional and based on my mental illness, which I deny. This has the effect of calling my testimony falsified and untruthful and without my permission. That is not the conduct of my advocate, but my adversary. This, along with your continued failure to keep me reasonably informed, is one reason for the complaint I have filed against you with the Washington Bar Association. You have based your opinion on Mr. Ledoux's evaluation. I can discredit her professionally at any hearing, but if I told you what I have, you and I both know you'd be on the phone to her trying to warn her and neutralize it. Clearly, you are no longer acting as my advocate. On a remand under 4247, I am entitled to the appointment of counsel to defend against your allegations of my incompetency. You cannot wear both hats. Your continued efforts to remain my appellate counsel in light of our clear conflict of interest is also a basis of my current complaint to the Washington Bar Association against you. Your characterization of my testimony as delusional, false, undermines my credibility with the Ninth Circuit and is not accurate. Your failure to recognize the prosecutorial misconduct in my case and instead rush to judgment that I'm suffering mental illness clearly is harmful to the credibility of my trial defense and to me personally. It further serves to help cover up the prosecutorial and law enforcement misconduct that took place and in effect denies me an opportunity to present the same to the Ninth Circuit for remedy. With all due respect, I do not want you to continue as my counsel, and it is in fact quite unethical for you to try to do so. Please withdraw from my case on your own motion immediately. Wow, he really told Suzanne Lee Elliott off. That's a good letter there. Sincerely, Francis Schaeffer Cox. Okay, I'm going to stop here on page 21. Stopping on page 21.